All right, let's begin. Today, we are dissecting one of the most tested and, frankly, most treacherous areas of contract law: acceptance. Specifically, we're wading into the battle of the forms. Now pay attention, this isn't just theory for an exam. This is the reality of commercial litigation. Get this wrong and you've committed malpractice. Let's get to work.
So here is the question that lies at the heart of it all. What happens when the acceptance doesn't quite match the offer? It seems straightforward, doesn't it? Well, it's not. In the world of business, with purchase orders and invoices flying back and forth, all littered with fine print, the answer to this question determines everything. It determines who's on the hook, who bears the risk, and who gets dragged into arbitration. This is where contracts are won and lost.
Here's our roadmap. We'll start with the common law rule that created this whole mess, the mirror image problem. Then we will take a deep dive into its solution, UCC Section 2207. After that, we'll see how courts have battled over this statute in landmark cases, tackle the modern fight over shrink-wrap contracts, and finally, we'll ground ourselves in the fundamental principles of acceptance.
Okay, first things first. Before you can appreciate the genius and the complexity of the Uniform Commercial Code, you have to understand the rigid, inflexible problem it was designed to solve. The common law had a rule that was beautifully simple in theory and an absolute disaster in practice for modern commerce.
See, under the old common law, an acceptance had to be a perfect, flawless mirror image of the offer. Any deviation, any at all, wasn't an acceptance, it was a rejection and a counteroffer. This gave us the last shot rule, where the person who sent the last piece of paper before the goods shipped got to impose all of their terms on the deal. It was arbitrary and frankly unfair. The UCC came along and said, this is absurd. If the parties act like they have a contract, we're going to find a contract, even if their forms don't perfectly match.
All right, let's get our hands dirty and dissect the statute itself. You need to approach UCC 2207 like a logic puzzle. It's a step-by-step analysis. If you master this analytical framework right now, you can take apart any fact pattern the bar examiners throw at you.
Okay, track this closely. Subsection 1 tells us that an acceptance is still an acceptance even if it has new terms, unless, and this is a big unless, the acceptance is expressly made conditional on the other side agreeing to those new terms. So if it's not expressly conditional, we have a contract, period. Then we move to subsection 2 to figure out what to do with the new terms. Now, if both parties are merchants, the new terms are in unless one of three things is true. The original offer said, no new terms, the new terms materially alter the deal, or one party objects in a reasonable time. But what if the acceptance was expressly conditional? Well, then the paperwork does not form a contract. Instead, if the parties start performing, shipping and paying for goods, we jump down to subsection 3. This creates a contract by conduct, and its terms are only the ones the parties agreed on in their forms. Everything else gets knocked out, and we fill the gaps with the UCC standard terms.
So that's the theory. That's the statute. But how does it actually work in a courtroom when real money is on the line? These next couple of cases are absolutely foundational. You must know them. They show how judges have wrestled with this thing in practice. So let's look at Dorton. Here, the dispute was over an arbitration clause buried on the back of a seller's form. The form said the deal was subject to all its terms. So the question for the court was, is that language, subject to, strong enough to make the acceptance expressly conditional? The court's answer was a clear no. It said that to hit that high bar, the party has to make it absolutely clear that they will not proceed with the transaction unless the other side agrees to the new terms. Subject to is just too weak. So a contract was formed by the exchange of documents. The court then sent the case back down to figure out the next step. Was that arbitration clause a material alteration? Now compare that to diamond fruit growers. This is the perfect next step. Here the seller was smart. They did use the magic language. Their acceptance form was expressly conditional on the buyer agreeing to its terms, including a massive disclaimer of liability. The buyer objected, but kept buying the goods. The seller argued, hey, you accepted the goods, so you accepted my terms. The court said, not so fast. When an acceptance is expressly conditional, assent from the other party has to be specific and unequivocal. Just performing the contract is not enough. The court saw right through this. It was just the old last shot rule trying to sneak in through the back door. So because there was no express assent, the writings failed to form a contract. Instead, the party's conduct created one under 2273, and the seller's self-serving disclaimer, it got knocked out.
Okay, let's pivot from battles over paper forms to a very modern and, very contentious battleground, the shrink-wrap contract. This is where the terms and conditions are literally inside the box you just bought, and it has created a massive split among the courts on how we think about acceptance.
So one line of thinking comes from the Seventh Circuit, from Judge Easterbrook, in famous cases like Pro CD and Hill versus Gateway. His argument was this: the vendor is the master of the offer. The offer isn't just the computer on the shelf, it's the computer plus all the terms that come with it inside the box. So you, the buyer, don't actually accept the offer when you hand over your credit card. No, you accept later by your conduct, by opening the box, reading the terms, and then not returning the computer. In this world, UCC 227 is totally irrelevant because there's only one form being sent. And the result? Those terms in the box, including that arbitration clause, they're part of the contract.
But then you get a case like CL610 versus Gateway, which comes along and says, whoa, 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 the Seventh Circuit has this completely backwards. This court argued that in a normal consumer sale, the buyer makes the offer when they place the order. The vendor accepts that offer when they ship the product. You see the difference? This means that all those terms inside the box are nothing more than a written confirmation that contains proposals for additional terms. And that puts us right back inside the world of UCC 2-207. And since the buyer, Mr. CL610, was just a regular consumer, not a merchant, those extra terms were merely proposals. They required his express, affirmative assent. Just keeping the computer, that's not express assent, so that arbitration clause was out.
So look, here's a split in a nutshell. It all comes down to two simple but profound questions. 1, who is making the offer? And 2, when is the contract actually formed? The Pro CD and Hill view says the vendor is the offerer and the contract is formed late, after you've had time to review the terms. The Klatchik view says the buyer is the offerer and the contract is formed early when the product ships. That one analytical shift determines whether UCC 2-207 even applies, and it completely changes the outcome. You need to be able to argue both sides of this.
All right, now that we've wrestled with the UCC and its modern applications, let's take a step back. Let's zoom out. Because all of these complex rules are really just built on top of a few fundamental bedrock principles of what it even means to accept an offer. If you understand these, you can reason your way through any acceptance problem, whether it's under the UCC or not.
The Fujimoto case is a masterclass in the method of acceptance. You had 2 key employees about to quit. The company offers them new contracts with bonuses. They sign them, but they never actually hand them back to the boss. So did they accept? The court said absolutely. Look, the offer didn't say you must return this signed paper to accept. It was silent on the method. Therefore, any reasonable method that communicates assent is good enough. And here, these guys staying on the job after being on the verge of quitting, that was an unmistakable signal that they accepted the deal, and you can be sure the company knew it. The takeaway here is crucial. Conduct can be acceptance. Actions speak.
And finally, we have Swift versus Smigel, which deals with the termination of an offer. Now, the ancient common law rule was harsh. It said that if an offeror dies or becomes legally incompetent, the offer is just gone. It terminates automatically, even if the person trying to accept has no earthly idea what happened. The court in Swift looked at that old rule and said, this is a relic. It's outdated. The modern approach, the better approach, is to protect the reasonable expectations of the offeree. If you accept an offer in good faith and you have no reason to know the offeror is incapacitated, a contract is formed. This is about fairness. It protects the party who reasonably relied on the offer.
And that brings us to our final question, one that you need to be thinking about. This idea of acceptance by conduct is the common thread through so many of these cases, from the employees in Fujimoto to the computer buyers in Hill. But I ask you, in our world of endless click-wrap agreements and terms of service that nobody reads, that we supposedly accept by just scrolling down a page, does acceptance by conduct still represent a genuine meeting of the minds? Or has it just become a convenient legal fiction that we all use to get things done? How you answer that will shape the future of contract law. That's all for today. Master these concepts.